oof, that is no, but I'm desperate and I'm tired. I've been working 24 hours a day for 10 years. Yes, okay, we'll do it.
The most exclusive part of the business law.
We're going to dig into business law as usual. And today we're going to talk about if you're afraid to selling your company too cheap. And there's a very interesting clause that we're going to talk about, the Anti-Embarrassment Clause.
Anti-embarrassment. You do not want to get embarrassed.
Exactly.
So, I mean, in particular, now we've had COVID, we've had such tough times, right?
Yeah, a lot of people sold their businesses.
A lot of them felt they had no choice and sold the business, in their mind at least, too cheap, right? Because they felt the pressure, they could not find a buyer at a higher valuation. And if you are in that situation and you feel that this buyer, he might actually be lowballing me just to turn around and flip and sell the company to somebody else at a higher price, then you can demand in the share purchase agreement an anti-embarrassment clause.
Is it as it sounds?
It is. So you don't have to be embarrassed when he does sell it to somebody else at a higher price within short. So we can take an example. Imagine that you're approached by Mr. Greedy and he wants to buy your company for 10 million.
10 million.
10 million. And you feel that, oof, that is no, but I'm desperate and I'm tired. I've been working 24 hours a day for 10 years. Just, okay, we'll do it. But at the same time, you are wondering if Mr. Greedy will flip the company and sell it to somebody else within short. So you can say to him, okay, I respect your valuation of 10, but I want an anti-embarrassment clause that says that if you, within 3 months, sell the company to somebody else, I get 50% of the proceeds. And if you sell it within 12 months, I get 40% of the proceeds. So in this case, let's say it turned out to be true. So we bought the company from you
For 10 million.
For 10 million. And then Mr. Greedy, only 14 days later, went and sold the company to a valuation to a price of 50 million.
Oy.
But then you have the anti-embarrassment, which basically it's a profit-sharing arrangement. And in this case, you demanded to get 50% of the purchase price. So he has a right to subtract the 10 million he paid you in our agreement. And then you have 40 million left. He split that in half. So instead of only getting the 10 million, you end up with 30 million.
Wow. That's a really good clause.
That's a really good clause. And the beauty of it is, since it's a profit sharing, the buyer does not have to take risk at the higher valuation, really, because it's only if he gets to sell it at a higher valuation.
Exactly.
And you don't have to get embarrassed if he sells it at a higher valuation. And just to kind of give a context, why would you do this, right? And basically, it's because if he sells it within really short, then realistically, in most cases, he will not have added any value. It will be your hard work, that made it worth 50 million, not what he did. So that's why he can accept the profit sharing if you suggest it, and of course, argue and negotiate for it.
Okay. So if you don't want to be embarrassed, you need to be very, very, how do you say, to have the clause in a deal.
And 50% was only an example, of course. You can
do however you want.
Exactly, it's up to you.
Okay. Interesting. Thank you so much.
Thank you. And I really love the name.
Yes.